Hi, everyone. My name is Suzanne Garcia. I'll be presenting today with my friend and colleague, Bonnie Claremont. Do you want to say hi, Bonnie?
Hello, all. This is Bonnie from Minnesota.
So we're going to be having a conversation today about how victim advocates and attorneys or legal advocates, as the case may be, can work together in divorce and custody matters to ensure the safety of the survivor and their children if they have children. Um, and just generally, we're hoping we can have a conversation about this, so we invite you to join us. We also have our colleague Kelly Stoner here today, so she'll be providing support. If you have questions, you can put them in the chat. And I also believe that if you want to come off mute and have a conversation, we can do that too. Our work today is funded through a grant by the Office of Violence Against Women. So the opinions, findings, conclusions, and recommendations are ours and not theirs. Um, these are today's learning objectives. So we really, like I said, we really want to have this to be a conversation about how victim advocates and attorneys or legal advocates can work together. So we're going to be walking through just a refresher on civil jurisdiction in divorce and custody matters. We're going to be looking at specific code sections that are often put in place when domestic violence, sexual assault, or stalking are present, and that can help protect your client and the children. We'll be talking about custody, protecting enforceability, and also child support. We'll have a conversation about visitation, and also we'll be talking about how to promote safety, both physical and digital, for your client. We're going to talk about empowering your client's voice. And finally, we're going to talk about animals and pets and tips for their protection in these kinds of cases.
Can I add one thing?
Yes, please.
Well, I'm really old school, so I really invite you all to just chime in or not be afraid to put something in chat and let's just kind of visit, right, about all of these because they're relevant to us and all our work. But I also want to add just a note about I can't stress the importance to, especially to advocates, about the importance of staying within our professional boundaries. And it gets tempting because the people we work with trust us as advocates, right? I call myself an advocate. I always will. And they may see us as being able to give legal advice and so forth. So I just want to add that to sort of guide us as we visit about these different issues.
Thanks, Bonnie. Yeah, and that's what I'm hoping we're going to be talking about, those boundaries where those, as the conversation goes, we're going to be talking about where those boundaries might be. And like she said, just have a nice visit here. Next slide, please. Okay, first topic, we're just going to review civil jurisdiction for these divorce and custody cases. So knowledge check, please place your thoughts in the chat. What jurisdictional issues do you have to be mindful of when you're thinking about what court to file in? And also, what if something has already been filed and you'll be responding? So we're hoping to kick off the conversation talking about what jurisdiction might look like, what issues that you've come across maybe. So when you're talking with your client about where to file and you're working with the victim advocate about which court to file in, what kind of jurisdictional issues do you have to look at? Or do you have to be mindful of? Okay, Brooke's talking about where is the client and what's the usual residence of the kids. Yep. Human rights. Mhm. Okay. Henrietta says that most family members are in tribal court, family matters are in tribal court, while the criminal will go with the county. Victims' rights, absolutely. Um, there's an incident of domestic violence, where it took place, and who the parties were. Yep. All right, so let's go to the next slide. So all of these that you put in the chat, um, but the technical term personal jurisdiction, subject matter jurisdiction, and special rules around protection orders. Next slide, please. All right, so personal jurisdiction in Indian country, and I use that as a term of art. That's on tribal lands. Um, so if the parties are member Indians of the tribal court you're working in, it's usually broad, it's expansive, and generally exclusive except where public law 280 or where there's concurrent jurisdiction. If the opposing party is a non-member Indian, it's more extensive than over non-Indians, but maybe more limited than over members. For a non-Indian, it's presumptively limited. So you have to be careful there. A tribe's civil authority over a non-Indian is limited, according to Supreme Court cases, and it might fall under one of the two Montana exceptions. And the court you might be working with might not technically ask for that, but it's really good to lay it down in the record just in case it gets appealed. Next slide, please. So when you're doing this, the goal is to protect your client. And Bonnie and I were talking about this. We were talking about, when you're looking at which court to file in, your number one goal is protecting your client. And we were talking about, again, roles and responsibilities. But if you're coming from far away and you're not familiar with how the local practice might look where you're working, it might be good to pair up with a victim advocate who might know about whether there's any kind of enforcement issues. They might also be able to help you get a copy of the tribal code if you can't access it, and look at what cases the tribal court, where have they exerted their jurisdiction, and if there's concurrent jurisdiction, what have the two sovereign parties agreed to? Bonnie, what do you think thoughts on what role the victim advocate can play in helping everyone figure out which court to file in?
Just based on trusting the advocate, the grassroots, I don't know what to call them. They're not legal. They're not lawyers. They don't work in prosecutors' offices. They're, either tribal or nonprofit. Those advocates, which many of you are, you have developed relationships and you have a history of how different jurisdictions have functioned, how well they meet the needs of Native victims who seek protection in their courts. So you have some knowledge of that I think the lawyers need to be aware of. That's where collaboration is so important, and also just being able to take time to better understand the non-tribal jurisdiction and those issues, those problems that arise, and have them addressed in some way as they arise, as they come up. So, and a lot of advocates do that kind of work, and that's value. That's just invaluable to lawyers to have that kind of history, that kind of knowledge. Some,
Absolutely.
some lawyers in some areas aren't even aware of VAWA, right? So, and just the new laws, the special jurisdictional issues.
It's true. And I'm going to drop a link to a case here. So as those of you who might be practicing in the Eighth Circuit, um, there was a case that got made its way up to the Eighth Circuit, and the lower court had decided that the tribal court did have jurisdiction, but the Eighth Circuit overruled that. Um, so I would caution the attorneys in the room that if you have a case that might affect the tribe's jurisdiction more broadly, and it might affect the jurisdiction of other tribal courts, I would highlight. I was former in-house counsel, so I would really want to be talking if I thought that like a case like this might be coming up, to talk about protecting your client's safety, but also protecting tribal sovereignty. Okay, next slide, please. So Bonnie was talking about VAWA. So protection orders in Indian country are addressed under VAWA. So if you have an incident that in matters arising anywhere in the Indian country of the Indian tribe, they have full civil jurisdiction to issue and enforce protection orders involving any person. So you don't have to necessarily be concerned about the Montana test on these ones. If you have a tribe that is exerting the special jurisdiction, they should be able to issue protection orders and have them enforced. And that's something else that I think are conversations to have with your client and also conversations to have with the victim advocate. Because Bonnie and I were talking about that, it's they have the authority and they should be enforced, but the victim advocate might know something about local law enforcement where they're, the non-tribal law enforcement where they're not enforcing those protection orders. And your number one goal is to protect your client. So that's a conversation to have. Bonnie, did you want to chime in about that?
I think it'll come up again, so I'll do that then.
Okay. Okay. Um, I had a situation where I knew local law enforcement in the county wasn't going to be enforcing the protection orders. So I left the tribal court and I went straight over to the state court to make sure that they were going to enforce it. I wanted to register the order there and make sure it was going to be issued because I just wanted to make sure that my client and her kids were protected.
Yes. And I'm sorry, that's what we mentioned or talked about in our conversation yesterday about the importance of, getting these protection orders wherever a victim might travel to, even so that, there's that preparedness, and you'll get to know, if they have any questions, if they're going to have any problems enforcing, to be able to work with the local law enforcement with where the victim may travel to.
Yep. Okay, next slide, please. All right, so we're going to talk specifically about jurisdiction for Alaska Native nations. So Public Law 280 only applies in Indian country. And under a Supreme Court case, the lands that were transferred under the Claims Act are not considered Indian country. So there's a really good quote that a gentleman, and I'll put the link to his law review article, talked about how if reservations across the United States are checkerboards of jurisdiction, native lands in Alaska are a three-dimensional chessboard. And it's true, it's more complicated there. So that's a nice law review article that you might want to read. But they have the Supreme Court in Alaska has affirmed the tribe's inherent jurisdiction over matters involving personal relationships between tribal members, and with a specific emphasis on the need to protect kids. So that jurisdiction is grounded in membership in the inherent sovereignty of the tribe. Janie, I see a note in chat. Did you want to come off mute or did you want to put something in the chat? We see your hands up. Okay. Um, so I'm going to put a link to a couple of cases in there. So we've got John V. Baker right there. Um, I know we're not talking about ICWA here, but I think in order to take a look at what the Alaska Supreme Court has said about the importance of tribes having sovereignty to protect their kids, and that jurisdiction be based on membership, I think these are important cases to know. And also, more recently, they have affirmed that tribes have the authority to decide and have their child support issues also um, also enforced. So, um, so that's Alaska. All right, next slide, please. Yep, go on to the next one. I got ahead of myself. Okay, so for protection orders, the laws here again are a little bit different. So they had to, the special criminal jurisdiction under VAWA is a little bit different because the amount of Indian country in Alaska is limited. So where it is Indian country in Alaska, that's Public Law 280. But outside of Indian country, VAWA is tied to the villages, and that's a specific term of art that you see here on the slide. But outside of Indian country and the villages, you probably have to show personal jurisdiction under Montana, and so you're going to need to lay that down on in the record. Bonnie, did you want to chime in about our friends in Alaska Native Nations?
Um, there's so many challenges. I think we need a whole webinar probably to address all of the challenges that I've seen exist in Alaska to with issues related to protection orders, but just basically even enforcement with law enforcement being very limited in their abilities and so forth. So, yeah, there's lots to be said and done there.
Thanks. Okay, next slide, please. All right, so now we're going to talk about different code provisions. So a lot of tribes and a lot of jurisdictions have special code provisions in their code that if domestic violence has been present, it directs the court to take certain actions in divorce, custody, visitation matters. So we are hoping that you could talk about some civil code provisions that you've seen in the tribal codes and the state codes that you work with, and how are they implemented where you practice. What kind of code provisions have you seen that have helped you protect your clients? All right, next slide, please.
Could I say a word about this?
Yes, please.
I think, tribes are sovereign, right? And they have control over their laws and what they can put in them. And I really encourage when the times that I do have the opportunity to do any kind of code development training, I encourage tribes to look at their cultural traditions and their values about safety and protecting their citizens. And how do you do that, from beginning to end when we talk about enforcement? So, including even um, organizations or services that work with batterers, with the abusers, and probation, and so the whole gamut. The more you put in there to cover those things, people then pay attention because it's written in law, right? So the more language you could put in there from beginning to end, the better is what I suggest. So when we're looking at what's good, what are good codes, I say the better. More is better.
If I could, I want to tag on that. I agree totally, Bonnie. And I would just add that it's not, I don't want to say it's common, but to me, it's not unusual to find in a tribal code that if the judge finds domestic violence has occurred, there's a presumption that the offending parent should not have custody. You may have that in here somewhere, but I just wanted to say, take a look at your tribal codes because I do see that coming up when we do code reviews at TLPI.
Yep. So and so we have someone here that they've seen a provision that prohibits judges from denying a protection order due to the passage of time between a domestic violence incident and a filing of a petition. So the person can file even if there's time has passed, which is one I hadn't seen before. I think that's terrific. Um, the ones I have seen and worked with, prohibitions on mediation and counseling in cases involving domestic violence, protections when restorative justice methods are applied that they might not appropriate where domestic violence is present. We're going to talk again about that later. The one that Kelly just talked about, which is the presumption against custody for the perpetrator of domestic violence. Sometimes it's a presumption that it's in the best interest of the child to reside with the non-offending parent, the protective parent. And then a finding that if there's a domestic violence incident that happens after custody has been established, that's considered a change of circumstances, letting you go back to the court and ask for custody or visitation to be modified. And also, sometimes there will be a code provision allowing for special requirements when ordering visitation in cases involving domestic violence. So those are some of the things to maybe look for in the code that are going to help you protect your client.
One more thing I want to add, just because it came to mind, we don't have it in here. It's the failure to protect statute or language in the law. Be very careful about that because it's really based in, battered women returning to the abuser and how that's dangerous to children. And it takes away the responsibility for the abuse to begin with from the abuser. And it punishes the victim, the mother, oftentimes, or the non-offending parent, because yes, a lot of battered women do return to their abusers, and it's the actual witnessing of the abuse which is the problem, not so much of the battered woman returning, because there's a lot of reasons why battered women return to their abusers, lack
So
of
you're
resources and so forth.
so you're still seeing that in tribal codes that the
Oh
failure to
yeah.
protect is
Yep.
part there? Okay.
Yep. I'm asked
I,
about it a lot, and they're getting better. If it's there, they're at least they're aware it's there and ask how it can still be modified or somehow, worked with until it gets removed.
wow. I just wanted to add, as you're looking down through this list, if your client wants a protection order, you sometimes get that first before you file for the divorce and custody because she needs that protection. In that protection order, it's really important, and I think most protection orders have this in there, where the tribal judge finds there's credible evidence that domestic violence is occurring, that there's an offender there. Once you get that protection order with that finding, theoretically, that kicks in this presumption even before you may have already asked for custody in the protection order, but if you did it, or you're later going to do divorce and custody, that document kicks the presumption in. I think that's the way it was designed for those tribes who have that presumption in their code.
I like that. Now, if they had to get a protection order at the state court, do you think you could use that order the same way?
I absolutely, in a civil case, I
Yeah.
absolutely think you could use it. And I just caution everybody. I know you're going to talk about protection orders later, but sometimes a victim will show up for her protection order hearing, and the offender is there. There may or may not be an attorney, and the offender will just stipulate to the protection order, but not the finding that
Okay.
domestic violence has occurred. That's a legal maneuver, and I would just caution you all to think about that, talk to the client carefully about it, especially if there are children involved and you need to kick in the presumption, and explain that carefully to her.
That's a great tip. That's a great tip. Thanks, Bonnie. Have you seen, I've seen,
Kelly.
go ahead, Bonnie.
No, I just said that was Kelly.
Oh, whoops.
It's okay. I'll be Bonnie. I wouldn't mind.
Just quick.
Um, have either of you seen where, because sometimes law enforcement will issue a protection order when they come out for an incident or a no contact order? How have you seen those used?
That's not going to be, it's good, and if the tribal code says that's what they're supposed to do, they should do it. But
Mhm.
that it's probably not going to hold up to kick in a presumption because there hasn't been due process. We have to have a hearing where at least the offender has notice and opportunity to appear. If they don't appear, you can still get the finding, but it's that notice that's going to make that stronger, and the opportunity for a hearing.
Got it. Got it. Um, so I'm curious about if you've seen this, Kelly. It's on the next slide. I worked in a jurisdiction where um, uh, the tribal code kind of had a catch-all provision that's saying, okay, if you know of another jurisdiction, another tribal jurisdiction or a state jurisdiction that has these code provisions in there, you can ask the court to adopt them or use them if it's missing from that tribe's code. Are those kind of
Yes.
provisions still in there?
Yes, they are in there. Um, Sometimes tribes will default to federal law instead
Yeah.
of state law. Some will say federal law or state law if we have a gap in our law. And that would be the time you would go check state law to say, tribe doesn't have the presumption, but the state court does. And it's going to be up to the tribal judge to determine whether they're going to apply that or not. But I would certainly want to argue it if there's a gap in the tribal code.
Got it. Okay. And in the absence of the tribal judge allowing you to use those, the fallback, or if they're not in the code, the fallback is the best interest of the child. So you want to document the harm to the child. You want to document the continued harm to the survivor, to make those arguments when it comes to custody of the kids.
If I could add a piece there, and Bonnie, you're going to have to back me up because I usually don't do custom and traditions. But the best interest of the child is not what the state feels it is. It is unique to that tribal community. They have different kinship rules. They have rules about what is healthy and best for a child that may be very different from the state court. So when you go into tribal court, if you're going to be, you need to have yourself educated at some point about, and sometimes you'll find this in the tribal code, might say something like, I'm just recalling off the top of my head, women and children are sacred, they're to be protected, and the family is involved in the rearing of a healthy child. Bonnie, what do you have to add to that? Because I know you know so much more.
The role that a multi-generational household even has, you know, to to be a part of, any of that, like grandparents and grandparent rights and the role they play to a child is also important. And even the ceremonies that are part of raising a child, there's still a lot of work that needs to be done to make sure that those things happen. And it's hard when all of these issues are happening at the same time to allow, children to have the ceremonies around puberty and all of that. And then even, with children with going through pubescence and, who's the best parent for that, especially when we look at girls, maybe it's best that they be with their mother. And what are those issues when father has sole custody or sole ownership of the property, of the income and all of that, but yet it's the mother that plays a vital role because of the sacredness of that connection between mother and child, that should be protected and even strengthened rather than taking the children from the father only because the house is in his name and he has the job, he has the car, and so forth. But the cultural traditions are equally, if not more important.
And I just share a tiny little story with you here. I was in a tribal court in North Dakota, and it was a custody dispute. And the opposing counsel was arguing that mom had abandoned the children because she had let the children were actually living with the grandparents there. But that was a part of that tribe's, that was not unusual there. That
Mhm.
was not unusual at all. In fact, under their customs and traditions, that was like a best practice.
Mhm.
So I feel like the message here to at least the attorneys and advocates that aren't familiar with working in a particular Indian country, you need this background to know to know how to navigate and how to advise your client with respect to the best interests of the child. And if you don't, you will be humbled. You will be humbled because you're going in and you're arguing these state concepts in a sovereign that doesn't see eye to eye with the state. So, yeah, just flagging that for you all to be sure you get yourself educated on that.
How do you approach that though? So what kind of advice do you have, especially for baby attorneys or some who might be new to practicing in tribal courts? How do you approach those kinds of conversations?
Well, I made a lot of mistakes. I'm just going to get that out there. When I was, they were, the tribe, the community was so patient with me. And there were a couple of elders that befriended me and taught me about the customs and traditions, but it wasn't, like I said, until after I made a couple of mistakes on my part. And one of the big things was the initial, probably if you all have heard me talk before, you've heard this story, and I apologize, but it was profound to me. I went to do an interview with a native elder, and she had brought her granddaughter. And I was so intent on being my lawyerly self that I, there were long periods of silence. And I felt like I need to fill them in, like finish her answer. And she stopped talking. And the granddaughter told me on the way out, she said, "You know why she stopped talking to you?" And I said, "Maybe she was nervous because there are some language barriers too." And she said, "No, because you kept interrupting her. And so she figured what she had to say wasn't important." And that was such a lesson for me because every tribal community is different. And if you're going in as the non-Indian or the non-member going into their jurisdictions, you need to somehow get yourself educated. And I would say now, at this stage of my career, I would go straight to those victim advocates. They're working with her, they will teach me about it. Um, So you kind of have to check some of your lawyer things that you're doing in the state at the door of, or at the barrier of that Indian country. You may have to do things a different way there.
I love that. Thanks, Kelly. Bonnie, do you have any tips for attorneys who are going to be approaching victim advocates to learn about these things? Who may not know what they don't know?
You know, it's like it gets frustrating because, when I just about the time I think as an advocate that, I've covered my bases, we've done trainings together and we should be good. And then all of a sudden something happens like totally off the wall. So it's hard to predict. I can't say enough about the importance of even developing teams like the coordinated community response teams where you're all at the table, you're all communicating, you're all cross discipline, doing that cross discipline training and collaborative work. So you see each other, you talk to each other, you visit each other, you learn more about the other person's philosophies and their families, their community, their network. So I think the more you do that outside of the working, not outside, but like without the cases specifically or being in court or that kind of work, if you can develop teams where you're able to get at some of that information, then you know more about the people you're working with collaboratively and where they're coming from. So you can sort of nip things in the bud and provide that kind of cultural education outside of when they happen.
Because it's relational, right? I mean, it's not just about learning
Absolutely.
things. Yeah, it's
Yeah.
about developing that trust. And um, so I guess what I'm taking away from this is if you get invited to be part of a team to discuss these issues as an outside attorney, accept it. Um,
And while we're on the I'm sorry, were you done?
no, yeah, I am.
Okay. While we're on the topic of codes and code development, and I just want to encourage advocates if you ever have an opportunity to participate in code your tribal code development, do it. It isn't just lawyers that have that information. Anything you see happen, even within a cultural context, you can put that in your code. You can say, this is why this is important because this is our value. This is what we value as a tribe. And that's why this particular language is important within our code. So I encourage that because I came into the Tribal Law and Policy Institute as an advocate. I'm not a lawyer. I'm not at all law trained, nothing. But I had direct experience working with a lot of the legal issues and some of the obstacles that I brought in that might be helpful. So one of the first trainings I went to was helping a tribe in Michigan to develop their DB code. And then we were able to then put it in a practical you know, scenarios to say this is the reason why this language would be important. So all of these terms that we're using, I got to know those. Other advocates even got to know them, and then we're able to then even train the lawyers about some of the language, some of the victim needs, the rights that should also be a part of tribal codes.
And I just want to add one short thing on. I think it's super important, and I learned this visiting and working with a tribe recently. Read your codes. You don't have to read the whole thing front to back, but read the pieces that are involved in the cases that you're working with, because we're working in a multidisciplinary group setting, and the advocates were like, wait, what? That's in the code? That's dangerous. That's a safety issue. And so, and Bonnie, you always say what part of an advocate's work is working towards systemic change in the codes to make those safer and more useful. But some of the codes are older and they have notions that we know aren't really safe today. So go read those. And I always encourage the advocates, run them off. Put them in a file. Take them to court with you. You don't have to be a lawyer to understand those. And if you see things that make you what? This is really, they're going to put the burden on the victim for that? You need to mark those down and go to meetings and advocate for change there.
And if there's legal terminology that you're not familiar with, sit down and visit with a lawyer, your local legal services, and say, what does this mean? What does this phrase mean? What does this legal language mean? Just for your own benefit, so when those terms come up, you know what they're talking about.
Perfect. All right. We're ready to move on to the next topic. Sounds good. Next slide, please. All right. So we're going to go over child support and custody. Um, so I guess my advice would be to have thoughtful conversations with your client about their needs. Be thinking about how the child support is going to be delivered, enforcement issues, because they're usually enforcement issues, and be aware of the need for modifications and try to get ahead of that. Bonnie, did you want to talk a little bit about the role that victim advocates can, how you can help support attorneys who might not be as familiar with this area?
And working with the victim survivor, I try to separate out, the legal needs and really empower them to share those with a lawyer. A lot of the victim survivors we see often come in very confused, very, very confused about where they can go and what kind of services are available. And then as an advocate, we refer them, these are the options, and it's your choice, right? So just based on historic trauma, we have some trust issues about using certain systems, certain organizations, agencies, and so forth, because of having kids taken from us and removed from our homes. So it's a lot of times they're very apprehensive, but also they're a little intimidated by the language, the legal language. So it's important to take all that into consideration when someone reaches out to your organizations or your companies, whatever you call them. So that for me, that would be important. And where they are in just being assaulted, just probably more recently, they're afraid of losing their children to their abuser. So they're concerned about safety. They're concerned about how are they going to support their children, right? Because in domestic violence situations, the motive is for power and control. So the more that the abuser can maintain that with the finances, with the lodging, with everything, even restricting the victim from having contact with her support system. So she may not have a lot of support, right? Or um, so taking that all into consideration, when helping her is really important, where she's at in her healing, where she's at in her safety concerns, and just basic needs that she has. She may be more concerned about, how am I going to get my children to school? I'm in a shelter for battered women. And if she doesn't get her kids into school, then she's seen as a neglectful parent, right? Your kids aren't in school. You're neglecting your parental responsibilities. So all of these things come into light when a victim leaves an abusive situation. It's just walking the maze, and we'll show you that in a minute. But just walking through all of the different systems and agencies that a victim has to go through. It's like no wonder they don't want to leave, right? Because it's so intimidating.
What advice would you have? How can a victim advocate, because I've had a number of clients who um, tended to lean towards wanting or being okay with not pushing the child support is I guess is one way to put it, is the language. They're really tired of fighting. They know it's going to be an issue, and so they would be happy with divorce and custody order that gave them very little child support. What kind of advice would you have for attorneys in those kinds of situations? How can we work together to support the client in what they want to do, but also, make
Yeah.
sure that they're protected?
Victims coming out of abusive relationships, as advocates, we see the importance and work around that, the importance of re-empowering that victim by allowing her or supporting her decision making, right? So we provide resources, we provide information about, what these different services and agencies can do, what they can't do, and what to expect by reaching out to them and utilizing those different types of services, whatever they might be. And, child support, victims come from all different perspectives. There's some that, yes, I want it all. He makes a lot of money. I want that. My children need that. It's his responsibility. But we also have a lot of victims that say, you know what, I don't really want any of that, because then there's that connection. There's still that connection to the abuser. And, oftentimes child support enforcement doesn't happen, right? And it takes a lot to try to get the systems to work to enforce what's been ordered, and yet this guy could be making good money. They could be off on the powwow trail, singing and making a ton of money as a singer, and it's all tax free pretty much, right? There's not many powwows that have their W-9s or whatever you call them. So, making a lot of money. So even there, I've worked with victims to video record when the group this guy's singing with wins first place, and they each get, $1,000, $2,000. I've worked with victims to share that video with their lawyers to say, look, this is how much he just won. And yet, he hasn't paid child support for months, if not years. And I've worked with victims that have had their abusers arrested, even at a powwow, for non-support and sent off to court, jail and court. So, yeah, there's victims that come from all walks of life. Some don't really want child support; they want their children, and that's it. Just give me my children, and may consent to some visitation, exchange, and so forth. But we encourage, to safety is number one. However, you can do that in a safe way is really important.
Kelly, did you want to pop in here? She might have
Yeah,
been.
no, I'm sorry. I was trying to take a bite of something. The only thing I would say is from boots on the ground legal work with domestic violence victims, when that child support order is issued, I would need Bonnie Claremont at my side advising the client. That is for me, a danger flag. So I want to make sure that's going to go smoothly. And if the client is heading in to get from either a tribal child support enforcement unit or a state child support enforcement unit, they assign their rights, and the state will provide the money and then go after the offender for the money. That also is a huge red flag. So Bonnie keeps saying it, you need to be thinking safety on every step here. Everything you file, every hearing, after the hearing in the parking lot, you need to have safety on your radar.
Perfect. Thank you. Okay, next slide, please. All right. Now we're going to be talking about custody with a special focus on enforceability. So with custody, what enforceability issues, and this is for everyone to put in the chat, what enforceability issues do you think you need to be aware of? So you've got a case, you're all in tribal court. The court's going to determine the custody of the child. what kind of things, as the attorney and as possibly the victim advocate, what kind of things do you think you need to be thinking of, as Kelly said, to ensure the safety of your client and of kids? All right, let's go to the next slide, please. Okay, so Brooke is wondering, can the abuser use enforcement to continue to control the victim? Yeah, so enforcement of custody. Brooke, are you talking about enforcement of custody orders and visitation orders? All right. Um, so UCCJEA, yes, contempt, etc. Yeah, that's one of the things you absolutely need to be thinking of. Um, so there's a couple of, these are the UCCJEA is a code that a lot of states have, most states have adopted. Um, and they will talk about, it talks about that, and they will treat other state jurisdiction or they will treat tribal jurisdictions like state jurisdictions. Um, so it's a set of rules about which court has jurisdiction to issue the custody orders, um, and how they're going to be enforced. Um, so to expedite enforcement of an order, you can have it registered with the state court. So when, if they have to go shopping off the reservation, you want to make sure that these custody orders are enforceable no matter where your client may be. So it's really important to make sure that the order has, the reason why there was jurisdiction, and it's also important to think about where they might be traveling, so those custody orders will be enforced. Kelly, did you want to pop in?
Yes, I have a little story here for you all. So, this to me, it depends on which state you're in. Alaska, that little piece Suzanne went over that says that states have to treat tribal orders like they would another state order. Alaska left that part out. But what that does, and I was always excited to use this in tribal court, because what happens is by state law, the state has to enforce the tribal custody order. And sometimes it's better in some places than others. But this is using state law to force the state to enforce the custody order, but only if you follow the rules of the Uniform Child Custody Jurisdiction Enforcement Act, the UCCJEA. And the biggie is, was this the home state of the child? We're in Indian country. The rule says where the child has resided with a parent continually for 6 months before the filing. So 6 months, I would ask the tribal judge to make a finding. This was the child's home state. Very interesting, because I got drug into state court over this custody battle. And I was able to take that tribal court order and say, Your Honor, by North Dakota state law, you have to enforce this. And he was very grumpy with me about it, but he did it because I was saying things like, well, for purposes of appeal, Your Honor, I need to find that you're not going to follow your state law. And this is a very powerful tool. If you use it and ask the judge to put these provisions in your custody order, it actually, in most cases, I think 48 of them, requires the state then to enforce it as it were an order from another state. So just tossing that out there.
So it's super important to get that home state language in the order. lay down all the reason why it's the home state and the
Right.
finding and all of that. Um, and then if you know say the um, non-custodial parent lives off the reservation, and the kids are going to be going there. I mean, even the states have a hard time figuring this out. There was a news story recently where mom lived in Nevada, or mom lived in Utah, dad lived in Nevada. Dad refused to give the kids back after visitation. And it took much longer than it should have, because they had to go after the fact and get that order registered under the state court in order for the state authorities to enforce it. And the picture is a bunch of guys with rifles surrounding a house. And, this is something you're trying to prevent the kids from going through. This is something you're trying to prevent your client from going through. So, have these conversations with your client about where they might be traveling to and be proactive about that, because number one is safety.
And that was the scenario I had, Suzanne. I had someone who lived in Devil's Lake and someone who lived on the Spirit Lake Reservation. And that child was going back and forth. And we had a scenario where we were going to have to go into state court and get the judge to honor the tribal court orders. So
Mm-hmm.
yeah, very powerful tool. If you're if the Indian or if the client even is going to be traveling to other states, you want to just kind of look it up.
Bonnie, what would you see as the role that the victim advocates can play? Say so you get a call from an attorney from a completely different jurisdiction. They're practicing in one tribal court, but they know their client's going to be somewhere else. How can the victim advocates help the attorney figure out how to ensure the safety of their client?
Preparedness. It's important for anywhere the victim is going, it will be with the children especially, and to make sure that jurisdiction is aware of the protection order and the custody and the domestic violence that's happening, and the importance of safety. I just talk with victims that I work with to have copies. Of course, there's still, all of that with, violation happening all over the place with with protection orders, with custody, with visitation, and it's just, it gets a little daunting for victims because they feel like, oftentimes they'll say, "I'll just stay home," and they'll deny themselves the opportunity to, take their kids places because they're afraid of the abuser, and having the abuser take the children, or going someplace where they're supposed to get the child back and not having the abuser show up and take off with the children. So, it becomes just a huge problem for a lot of victims. But I say preparedness is important. Take copies with you, whatever your orders are, take copies and share them with local jurisdictions. And there's a lot of, there's court clerks that can help, maintain that, even if nothing else, to get the name of someone who you're turning that paper over to so they're aware of it. So when you call about it, if something's happening, then they have something on record there, or they have it available they can look at.
I like that. Supporting the victims, even after the case is closed. As an attorney and working in collaboration with your victim advocates, you can really play a big role in the continued safety and wellness of your client, which is, of course, what you want. Um, Next slide, please. So I just want to mention the Parental Kidnapping Prevention Act. It mandates that states enforce orders from other states. This one doesn't treat tribes as states, but I wanted to mention it because it's out there. There is a good flow chart that you might want to look at to help you understand. And this one, it includes ICWA, It includes the PKPA and the Uniform Child Custody Jurisdiction Enforcement Act. So I thought it was a good resource. And it just kind of gives you it gives you a lot of information about the difference between all of them and how you can use them to protect your client. Okay, next slide, please. All right, now we're going to be talking about visitation and protecting your client and the kids. So these are some terms for visitation that you might want to consider including in your orders. As with everything, you should really have some thoughtful conversations with your client about whether these are appropriate or not. I used to put the right of first refusal in a lot of my visitation orders so that, you know, if the offender is not going to be watching the kids, mom can keep them. But there's issues around that. Bonnie, did you want to talk about that?
Safety is always a concern. Any contact, with the abuser, they're, like I said, victims come from all walks of life. There's in all points in their healing, all points in trust issues, all of that, and it's important to have those conversations with the victim that you're working with, because they only know best where they're at and what the safety issues are. Because, the more contact, the more, the possibility of abuse can happen, whether it's verbal or otherwise. So it's just important to look at any time those contacts are happening. And oftentimes I've seen so often that, these are just, again, putting victims in a situation where they're going to be accused of being neglectful or being, what's the word, where they're trying to alienate parental per,
Right.
parental alienation or something. They set themselves up almost in the courts or in with lawyers for the abuser, that they're seen as somehow not cooperating with courts or the laws, and seen as a bad parent for not showing up with the child when they're supposed to, because they're scared when they're being threatened that the abuser is saying, I'm going to take my children because you're not doing X, Y, and Z. So of course, if you're faced with that, then you may not want to do that, that give that person the right to either way to take the child for something. So safety is always just so important, and going by the victim and where they're at with their safety concerns is important to check that out always.
So I'm glad you mentioned the parental alienation syndrome because that's been debunked all over the place. But it continues to be used from what I've seen and thought of um, in a lot of, especially the rural courts. So that's just something to be aware of. Um, so when you're crafting these orders, think carefully about, like Bonnie was saying, that contact. When the children are going to be exchanged, that's an opportunity for the abuser to continue to abuse your client. And so, Bonnie, what kind of so we used to sometimes, we would have the transfers be at law enforcement or the courthouse or someplace where there was people around. Um, have someone else drop off the kids, just to reduce the opportunity for that abuse to
Yes,
happen.
yes.
Um, what other kind of creative solutions have you seen for, the exchange or anything like that?
I think you mentioned them. Just as long as there's, not they're not just the two of them as the parents with the child, because you run the risk of, again, more abuse happening or intimidation, all of that. So um, there's visitation centers sometimes that are willing to help with the exchanges. Um, you know, Schools, even, you could do exchanges there because there's staff there that can monitor.
And the holidays and ceremonies, for the attorneys in the room who might not be familiar with the holidays and the ceremonies of a particular tribe. Um, what kind of a role can victim advocates play to help educate us and help make sure that those things are taken into consideration?
There are special times that, that are made for our children, like I said, through different rites of passage or um, that our children should not be denied because there's these issues that are happening. But at the same time, it should be done in a safe manner. So I really encourage to educate even your spiritual leaders about domestic violence, and so that they're aware, because some of them are still kind of, I don't know if they've been um, misinformed by even, colonization or like boarding schools where, they encourage people, if you are married by ceremony, then that's sacred, you should stay together, when that's not that it's not feasible because of safety concerns, and often it can be a life-threatening situation, right, and it's very harmful to the children. So even they'll stress the importance of, you have to bring your children, or you should bring your children to this is important to them, when there isn't those adequate safety protections in place, even in places like powwows and so forth, there where it's just really open, anything can happen. So
Yeah. And we've also talked about, we've already kind of talked about travel considerations, make sure that wherever your client is traveling to, they know about the court orders. So they're hopefully enforced more quickly, and the kids are not put through a situation, and your client's not put through a situation that really can do a lot of harm. Um,
yes, do your research ahead of time where you're going. Like in the summertime, there's a lot of powwows going on, a lot of ceremonies. So, check out the jurisdictions where you're going, and even make contact with them, contact with local law enforcement, that I'm going to be there with my children and we have a protection order, and, fax them a copy, email them a copy, whatever works. Or even better yet, go ahead of time and take a copy, and make contact with a specific individual, whether it's the you know public safety commissioner or whoever. Make sure you document who you talk to and say, I left a copy of the order with this individual, so they know ahead of time. So if anything happens, you can call that local law enforcement or the appropriate law enforcement agency to say, he's threatening me, or he's intimidating me, or he's, actually, he's had contact with me where he shouldn't have contact, or he's trying to take the kids, whatever the case might be. So you're one jump ahead by doing that.
so, and this could be a really thorny issue. So I was wondering what kind of advice you might have about um, other relatives of the abuser who might also be intimidating, also be doing harm to the kids and saying inappropriate things in front of the kids. When you're talking about visitation and custody, how do you, that, like I said, that's a really thorny issue. So what kind of advice would you have for the attorneys in the room about how to negotiate that? How to not negotiate it, but how do you do that so your client's protected, the kids are protected? Um,
I think it needs to be said, in protection orders, that, kids aren't sort of brought into the abuse that's happening between the parents to try to brainwash or somehow negatively influence the children, and include extended family in that, if they're going to have ongoing contact. I discourage that from happening while this is all taking place, especially, if there's been some orders for the abuser to get some help, because more often than not, the abuser's family is kind of in that person's corner, right? And oftentimes the kids end up being pawns, and they try to influence the kids to for information about their mother or the non-offending parent about what's going on, what are they doing, who are they seeing, have they been drinking, so it's just the less of that can happen, the better. And to somehow or another make that clear to the offending parent that, your kids need to be not included in all of this conflict that's happening between the families and between the abuser and the victim.
And it's the same with community events, and it's so um, what I'm trying to do here with Bonnie is show the attorneys in the room that this is where the victim advocates can really help you understand and the kinds of conversations to have with your client in order to put as much as you can in those court orders that are going to protect them.
There's a thing called the power and control wheel, right? We use that in a lot of our training where, abusers abuse for power and control, and they have a lot of different tactics. And oftentimes they'll use the children as a way to maintain power and control over the victim. So we want to, stop that from happening. Um, so just that's a good tool for educating your judges and other lawyers.
I'm pretty sure. I mean, I know it's been in other webinars that you've done, previous webinars in these series.
Uh-huh.
But I will make sure that it's also is a prominent role on the web page, on our web page for that. Um, okay. Next slide, please. All right. Now we're going to focus in a little bit on what we've been talking about this whole time, which is safety. But, specifically, we're going to be talking about the safety physically and online. So, in these divorce and custody matters, what kind of steps have you taken, do you think should be taken? And this is for everyone, if you want to put some ideas in the chat. How to ensure the safety of the victim and their kids. So what are some things that you've placed in orders or some work that you've done with your clients and with the victim advocate in order to ensure the safety of your client and the kids? Communication through apps. Like family. Okay, so Abrielle, and I hope I'm saying your name right, suggests putting custody communications through apps that save the messages. And she gives the example of Family Wizard. So the client doesn't have to share a phone number. That's a great one. Okay, next slide, please.
One suggestion, as you work with victims, really strongly suggest that they keep kind of like a log of anything that happens, whether it's digitally on social media or, by way of mutual friends, by way of anyone that implies there's some safety concerns, there's some safety issues, there's some protection order violations, there's custody order violations, anything that's relative to that. And a lot of victims may not see, victims think it's only abuse if he's hitting me, right? And yet there can be a lot of issues that can apply if there's firearms involved, if there's stalking involved, anything like that, to encourage your victims to keep track of that, to document, take pictures, do screenshots of things, anything that can be used later when if a victim has to go back into court with this information. That information would be really important. Dates, times, and so forth.
So that's the kind of advice that a victim advocate might be able to provide you. Um, and so Bonnie and I were talking about the different roles that the attorney can play and the victim advocate can play in creating a safety plan. So where do you think the boundaries for that are, Bonnie?
We have access, we have contact, and with victims, and they share with us with advocates about some of their concerns. And so safety planning is, you know, about safety wherever they are, safety in the home. There's practical things that they can do to keep themselves safe if they decide even to stay with the abuser. But safety issues like being aware of where the knives are, being aware of exit routes, um, working with your trusted neighbors. Should something happen, what can you do? Are they helpful to you? Are they more friends with the abuser than with the victim? Those kind of issues. Safety in the workplace, informing your coworkers about what's happening, and even helping them keep track, helping them take a picture if they see that person cruising by or being close by or even in the store looking for the victim, asking for the victim. So all of that is part of safety planning, besides keeping a bag packed in case the victim's going to leave. Safety planning in the courts, even there's courtrooms that you have to visit. What are the safety needs there? Where's the closest place to park to get into the courthouse? Is there a safe place to meet with an advocate or with a lawyer in the courtroom, away from the abuser, away from the abuser's family, before any kind of proceedings happen? So all of that is part of safety planning. So it's important to know that and keep that in mind, that a lot of advocates do that, and legal, lawyers can also do some of that, but mainly to ask the victim, what are your safety concerns? Are you safe right now? Do you need an escort to the car? What can we what can we put in place to help you feel safer at home, at work, at school, and so forth?
Love it. Um, what would you suggest? So if you have a client and um, their safety is being threatened, but they really don't want to go back to court, to pursue some of the remedies that might be available to them under the law, but they might not be. So how can victims, or how can victim advocates and attorneys work together to, you want to support the client voice, you want to, empower them, but at the same time, um, you want to make sure they're protected. Have you run into situations like that?
Are you asking me?
Yeah, yeah.
Oh,
So I'm
sorry.
wondering, yeah,
Um, I say first and foremost, the option to report anything to law enforcement. If a victim feels like their safety, their life is being threatened, the children's lives are their well-being, their welfare is being threatened by kidnapping, being aware of all of the different rights that victim has, informing them of those rights. Um, Anytime, at any time. Sometimes they're not being informed when an abuser is released from jail, for example. Somebody, it falls between the cracks and they're not informed. That's a huge safety issue. But, always the option of reporting things to law enforcement so there's a record of it. And also, like I said, to journal some of that information as they occur, so that there's a log of it, there's dates, times, and so forth. Um, I don't remember the question, the whole.
no, that's terrific because your client might not be ready to go back to court. She might never be ready to go back to court, but you've got to document everything. You've got to keep that
Mhm.
log that Bonnie was talking about. So if she does decide that yes, she wants to go to court or pursue exclusion from the reservation, get fines, fees, all those other things, um, work with them. everybody working together to document all of these things is going to make your case much stronger when you do go to court. Okay, next we're going to talk about digital safety. And we've had some great comments in the chat about these apps that will allow the parents to communicate in a safe manner. So can we look at the next slide, please?
I've never heard of that app. That's awesome. I'm technologically not very informed. So thanks for sharing that.
Yeah, so Kelly loaded me up with some others. So I'd heard of some. Let's see. Our Family Wizard, Talking Parent. There's another one called App Close and another one called We Parent.
Wow.
Yeah, and so it keeps the log and it allows for communication, but the abuser doesn't get the phone number. I've been told that some of these do charge a fee, but others have scholarships for DV victims. Some are free and some are on a sliding scale. So let's see. Give everyone a link here to find some of these. But work with your client to make sure that they have changed their passwords.
Mm-hmm.
That digital online safety, we all do so much digitally. That's how we set up appointments. That's how we communicate with each other. I mean, but really, really working with each other to make sure that their passwords are changed. If they logged on using the abuser's devices, what kind of have these conversations with your client. Turn off tracking devices and location services. And also, unfortunately, you might have to address tech-enabled trauma. So the posting of pictures and misinformation about the client. Everyone's on social media and there can be a lot of abuse done there. So looking towards those things is going to be really key. So in the chat, we have someone who's working on a case right now. The opposing party is using a third-party app to harass, blame, and threaten the protected person. There's no limiting language in the protection order. Oh, so make sure that limiting language, thank you, is included in the protection order so that communication is limited to only talking about or with the kids. That's a great tip, so thank you. All right, we're close to time, so we're going to move on to talking about pets and animals. Nope, we're going to talk about protecting, supporting your client's voice. So it's those communication plans like we were talking about and ensure the safety plan is going to be honored. So a lot of family law cases, they want the parties to go to mediation. There's also been a lot of work towards using restorative justice practices in domestic violence cases, but you really, really, really need to be aware of protecting your client's voice and also protecting them from having to confront their abuser in these practices. A lot of tribal courts will have codes that provide for those protections, so make sure to look out for them. Next slide, please. Okay, now we're going to talk about pets and animals. These are families, they're family members. Ensuring that they're included in the safety planning, make sure that there's an animal go bag, have current pictures of your pet, ensure that the pet files are under their names at the vet. There's a way to update the microchip registry, but don't put your new address. Don't put the phone number, use a friend's address or ask about privacy settings when you go to do it. And more tribal codes are talking about it because a lot of state codes treat animals and pets as property. But there's a lot of tribal codes that are moving more towards the best interest standard. And there's a great article by Sarah Deer on this issue, so I'm going to drop a link to the chat on that. Okay. All right. Next slide, please. Okay, so that's the end of our presentation today. Does anyone have any questions or would like to follow up and have a discussion about anything? Okay. Well, we thank you for coming here. We did want to announce that the tribal consultation is coming up in September, and that's a great place for attorneys to hear directly from the tribes about the challenges and the successes they've been having. This is a link that goes to the summary report that was issued back in January. And here's a link if you want to sign up for that consultation. It's going to be in Tulalip this year. I don't know if that's going to come up as a link. I hope so. And so we encourage all of you to please attend. If you can't attend in person, you can attend virtually. But if you do want to attend in person, we've been advised that you can use grant funds for that, but you got to work with your grant fund manager for that. All right, Marlon, do you take over for the evaluation slides?
Hi everyone, thanks again for attending today's webinar. If you have to leave early, the screen that when you close out, the window will pop up with our evaluation link. We're greatly appreciative of any information that we could use for improvement, topic discussion. As a reminder, this webinar is part of Art Legal Advocacy Year 2, brought to you by the Tribal Law Policy Institute as a TTA provider for the Legal Advocacy Legal Assistance for Victims, LAV, Expanding Legal Services Initiative, ELSI grantees, and other legal services located on or near tribal communities. Please visit our website, www.triballegalassistance.org. And let's go ahead and go through the closing information. Here on the screen, we have the dates for the upcoming webinars, the link that you used to join for today's, and for those listening post this recording, those dates would be July 15th and August 19th. And those brief descriptions and topics are available using the registration link for Zoom. And as a friendly reminder, you can find our information also posted on ta2ta.org website. Here's a little bit more information about our triballegalassistance.org website. I'm sorry, triballegalassistance.org website. And as a friendly reminder, questions or like further discussion about any of the topics or any of the previous webinar presentation materials, anything that's coming up, we provide TA. And you can find there is on the top of the menu ribbon on triballegalassistance.org, a TA request form. Here's a brief slide on the types of topics that you could request TA about. Our previous presenters, Kelly Stoner and Bonnie Claremont, were instrumental in getting some of the resources that we're going to display here on the next two website slides. Victims' rights here, you can access it through the UR code or the link. And again, we'll send out the PowerPoint deck. The PowerPoint deck as a PDF should have the link function available for access. And the same thing with the Pocket Guide, Tribal Victim Advocacy, Criminal Cases. Further, you can also visit our main website for our organization, home.tlpi.org/publications. And it's organized by subject and by series as displayed here on the screen. Here's our QR code again. So with that, I'm going to go ahead and pause the recording. And if any folks want to make any live comments being muted, we can do so at that time. But for the time being, we'll leave it displayed up on the screen.